Welcome. As I explained to those that are with me live, any question having to do with paralegal studies, get it to me, come live, such as we're doing now, or send it to me, course messaging. The term is over right away, but remember that you can send something to me, general faculty student email, after the course is over if you have a question about paralegal ethics or other paralegal topics, research, anything. And I'm just reminding you of phone number and email, because I don't keep checking the messaging inside the course when the course is over. Deadline for all work. Any questions about the deadline? So there's no more extensions. Yep. Tomorrow night. It's 0 points. And I realize a lot of folks have had severe problems, but if they did not complete the bulk of the work, they'll have to retake the course. That's just the way this works. It's not an at your own pace course. There are such things in the educational universe. There's at your own pace things and so on. But typically those things are based more on just taking tests or something, objective knowledge, and not on forming your thinking skills, forming your research skills, and gradually over a period of 5.5 weeks improving what you know, what you can do. And that's basically what this is about. I added to the objectives. The objectives in the course for Module 6 are here: analyze major principles on regulation, American Bar Association, explain, summarize. But the course rubrics, which is the scoring system, requires you to use enforceable state codes and case decisions. And what are those called? Are those called primary or secondary? Who knows? Okay, well, I'm glad you know it. Everybody doesn't seem to know it. Not everybody that's taking the course knows it, and I'm sad if they leave the course without knowing it. So I added it to the objectives here. If you don't know it, I want you to call me, even if you have to call me later, next term, whatever, because I don't want you to leave thinking that the ABA is in charge of something. They're not in charge of anything. How many think the American Bankers Association lends you money? If you apply to the American Bankers Association, will they lend you money? No. If you apply to the American Bar Association, will they suspend an attorney from practicing law? No. Thank you. I appreciate it. The students that are attending live know that. If you're listening by recording, tell the kids and the spouse, whoever's there, that you're in conference with me in a way you are. You should be writing down questions for me, maybe sending me a course message during your viewing of it, and tell them that you need to be in conference with me for an hour. and you cannot be interrupted. You need 1 hour of concentration time to get as much as you can and make sure you got takeaways from this course. If you get takeaways from the course and you compile them, they become a valuable part of what? Your portfolio, I think. What other thing might you call it? What do you want to tell an employer, maybe a present employer when you want to enhance what you're doing, and a future employer when you want to get hired? Wouldn't you like some specifics of what you learned rather than just to say, here's a list of courses I passed? I would. It's like experience. People say, well, I've got experience. And fine, you got experience. That might get you an interview, but it won't pass you at an interview. At the interview, they want to know what type of experience. Same thing with, well, I have skills from college, knowledge from college. What kind of skills and knowledge do you have from college? It's nice to have your own portfolio that you have yourself. Do they want 100 pages worth? No, but you have them ready, and you can rip out a page and hand it over the desk if you have to, or you could just look for it and find it. There'll be dozens of things that you know how to do at the end of. You knew somewhat before, but hopefully you know much better now. And then there'll be some things that you did not know really at all until you went to school, and you know them. I changed careers in my 50s from being a practicing lawyer to being an educator who is a lawyer. And I learned a tremendous amount in that time. So the fact that you know quite a bit now as an adult doesn't necessarily mean you cannot learn new things. Keep searching. Whatever course you take, keep searching for something instead of just trying to blank out your mind and think of nothing and hope that somebody fills your mind with something. I want you to have something you're looking for. What are you looking for in Module 6? What do you expect? You expect a summary? Maybe you could have a checklist. No, I can't name one. I'd have to research it, Cindy. Good question. Name a case where the attorney was sued for something their paralegal did. And a lot of times they would, I think I'll open a whiteboard, but one of the problems with that is that question, it's not a problem with the question is good. But one of the problems with lawyers is that they won't disclose that. It may be involved with the paralegal. The other thing is the lawyer is fully responsible regardless of what any employee did. Did to contribute to the problem. And I don't know if you guys can really see that there, but I'll give you an example that seems unfair, but it'll spark your memory. So let's say let's add or independent contractor. So lawyer hires who has experience working for lawyers. Ask the accountant, and it's like as the independent contractor. So accountant does not handle the trust account correctly. Does not account for? Who gets sued? What do you think? And who gets disciplined? I suppose the accountant could also be disciplined, but it would be separately. It wouldn't be in this, would probably be separately. So, yeah, the lawyer or law firm. And then, since an accountant, if it's a CPA, somebody that high in the accounting, maybe it would lessen somewhat the lawyer's responsibility to the ethics board, but I wouldn't bet on it, okay? But the same thing happens with a paralegal. Paralegal overbilled and overpromised. Tough luck, lawyer. And most lawyers wouldn't even attempt to defend based on that. I think most bar counsel would, somebody that defends somebody before the ethics board would pretty much just say, well, that's a loser. If you blame your employees, you're in big trouble. Yes, absolutely. Yeah, Jamie Nash asked a question. The paralegal was turned in for appearing in court. Wouldn't her attorney be turned in too? Well, the paralegal we're talking about, though, the paralegal that's sort of the lead character of the story, hasn't done anything yet, right? The previous paralegal is probably who you're talking about, yeah. The previous paralegal had done too much, had tried to represent somebody in court as if the lawyer was, as if the person was a lawyer and so on, and can't do that, and set fees without going over it without having the lawyer sign for it, things like that. I guess rule number one, when in doubt, get the lawyer to sign for everything in person, in ink, something where the lawyer has clearly approved it. Don't get him, if there's ambiguities, I guess you're just going to have to pass the buck on to the lawyer and say, it's just not going to work. I just can't do this. You want to have the lawyer committed on these legal judgment call decisions and these decisions on whether to accept a client, whether to proceed with something, what advice to give. Can you help? Yes, of course you can help, but get the lawyer to sign it. I wouldn't even just pass on verbally the final legal advice in the case. And you say, well, the lawyer said it, and I'm just repeating the exact words. I understand that, but the lawyer could come back later and say, well, that's not exactly what I said. Get the lawyer to sign for it in writing. There isn't a rule or statute in most states as far as what to do with paralegals that have violated ethics. That is where you'll have to use a secondary source in most states, like NFPA. Is that what you're asking? But every state has a rules of professional responsibility that apply for lawyers, and they're under the court rules. I'm wondering, though, if people realize that the rules of professional responsibility are not the only rules. There's also rules for the proceedings on professional responsibility that are different in most states, a different set of rules. Yes, yeah. We're getting good questions there. Paralegal portraying themselves as an attorney is illegal, like fee setting or showing up in court, yes. Even if they don't claim, if they say, well, I'm here as a paralegal, they can't do those things. Right. Right. But I wonder if you understand that the process of arriving at punishments is often, I think in most states, is under different rules. The rules, professional conduct, those would be the do's and don'ts. And then the rules for discipline. How does discipline happen? Are the stages. And rules of proceeding. I wonder how many found those rules in your state. Because if you aren't sure that you've got them, then let's find them tonight rather than leave or set. So this one is talking about enforcement. See, that's where the investigation process, that's not always clear from the rules either, but at least you can find out whether you have a professional responsibility board in your state. Investigation process. Potential outcome too. You can get some of that from cases. You get lists of cases and you will see things like disbarment and suspension. And you also get something that is, you might call probation, but it's not called probation. It's called supervision. Have you ever heard of supervised practice? Yeah, what is supervised practice? Now, my license is now inactive. I believe that I would have to activate it. I would have to pay an additional fee. If I paid an additional fee and got some insurance, I don't even know if I have to get insurance, but I'd have to pay an additional fee to activate my license. If my license was activated, then I could supervise another attorney. What would I do if I was supervising an attorney who was under a supervised practice rule? What do you think I'd do? Well, I would be looking in on what they were doing, on how they were managing their cases, and I would be looking at the trust, probably looking a lot at the trust account, somewhat at their business. There would be rules of supervision that would tell me basically what I needed to overlook, but I would be looking at several things to make sure that they were behaving ethically. I would look at, oddly enough, I would look at calendaring. And I would look at trust account. And of course, the calendaring would also have to be sophisticated enough that it incorporated a things to do list. and A, I would look to see how they open and close cases. And basically, I would be trying to figure out how organized they were. Can you see a role for paralegal here? Paralegals? Well, supervised would not be the same as what you're talking about, where someone is watching over the attorney if they're new to the field. The supervised I'm talking about would be the punishment type, where they're not allowed to practice unless they're supervised, usually by an outside lawyer, not somebody that they've been working with. In other words, I would receive no financial compensation or minimal if I did that. When it happened a few decades ago. Before I practiced law, one of the attorneys was supervised for a few months. That attorney got so far behind. The supervising lawyer basically had a skilled legal secretary who assisted the lawyer that was way behind and organized, okay? So basically organization, but these are the things that I would work on with the other attorney. A lot of it would be organization. So in a way, I would be the boss over that lawyer because I would say, you know, I have to report to court that you are behaving properly, keeping up on things, and that your trust account is square. But a lot of what I would be doing is checking basically the paralegal end of things. So I hope that kind of answers Cindy's question. So it's not often that a paralegal would be directly blamed by name in a case, but there are many instances where a good paralegal could do things to fix things. If you came in on a case where somebody was placed on suspension and they said, well, I'm going to be reopening in 3 months, but we need to get all of these things fixed in the meantime for me to reopen. This should be a question mark. Do they know when to turn down a new case? Lots of lawyers who have never been in trouble don't seem to know when to turn down a new case. Lots of lawyers who are good lawyers seem like they will just keep taking in cases, and that's too bad. One of the things I learned reasonably early on was that no matter how much people flatter a lawyer and tell them that they're the only one in the world that could handle this case or that is trustworthy, whatever, there comes a lot of times when a person has to limit themselves on what they'd be willing to take. When you're overbooked a little bit, you can work a little harder, a little bit longer, and you get it done. When you're way overbooked, you are just in difficulty, and you have to turn things down until you catch up. And obviously, employees are people. An organized employee is worth a lot for getting out of trouble and for staying totally out of trouble, okay? Module 6, a lot of this, some of this might not be plain to you, but I guess just do your best. So if your sources don't answer the question, if your primary sources don't answer this, cite them anyway so I know you looked, okay? Cite anyway, as you would if you worked for me. If you worked for me, I'd want to know where you looked, not just the gold nuggets. I'd want to know all of the other stuff you looked at, okay? Tell me where you looked. I paid people to do that. I remember one employee, Mr. E, apologized. He said, well, I didn't find the answer. I said, you found 35 places where there wasn't an answer. I said, I said, that's why I pay you. And thoroughness is just so overlooked. Some lawyers are maybe too dumb to pay for thoroughness. Don't work for them. Am I being too blunt? I don't mean to be hard on lawyers. But if you can be thorough with research, they should pay you for it if they've got their head screwed on straight. Lawyers are in a hurry, I understand that, but one reason you're there, or should be, is that you will look under lots of rocks that the lawyer will not take the time to look at. And tell them which rocks you looked at, even if you didn't find the gold, okay? And tell me that too. I looked at these primary sources, this, and this, didn't find the answer. Related cases didn't seem to have the answer, so here's a secondary source. But get your points for good reason, okay? Let me interrupt the normal presentation, and let's see if we can find some primary sources, rules of professional responsibility, and rules on procedure. Give me some states, and I'll write them down, and we'll just look at a bunch of states, okay? Type out some states. I mean, I know I can find Minnesota, but Wisconsin, Oregon, Pennsylvania, Illinois, Missouri. Okay. Did California show up there? Let me. Oh, California. Okay. Okay. I got my. This is always risky because you can. I call it capsize. I like to play the game capsize. But if you ask a question and I cannot answer it expeditiously, that's fine. Then you understand the scope of what we're trying to accomplish within your state. Eventually, if not today, eventually I want you to be better at your state research than I am. You should have home state advantage even on me, okay? Because you say, well, we don't have it where you have it in Minnesota. Our table of contents works a little differently. I love states, for instance, that have alphabetized statutes and things like that, and Minnesota is sorely lacking on some of that organization, but I'm used to it. Okay, let's take a look at the rules of professional responsibility and the rules of procedure, okay? And they have different names. Most of the basic substantive rules of professional responsibility have a very similar name, but some of the other ones, the rules on procedure, discipline rules that tell you somewhat the procedure are different. And then you may have to go to like secondary sources or other types of primary sources that are not in Lexis. You may have to look in state bar or just state court system where they talk about investigators and things. I don't expect you to answer thoroughly on investigators and that, because that is a little hunt and peck. But I want you to learn to use Lexis and find these basic rules, okay? Let's see. Got to get to the correct thing here. I think this is it. I've got too many things up. Okay, can you see this now? Can you see my screen? Okay. We're going to go to California first, which I'm expecting to be the most, perhaps the most challenging for me. And I'm told, I think that this will not be where the professional rules are. Is that right? That's where you normally look. You look under statutes and legislation and then local, state, and federal court rules. That's where you normally look in most states. And then, okay, and then I'm guessing that rules of State Bar of California, it must be like a mandatory bar that has some, under the Supreme Court of California, they would have some responsibility for lawyer discipline. So let's take a look at that. Okay, so, and then here would be the normal rules of professional conduct. Yeah, okay, so this is all familiar then. Okay, it's not too much different than other states. Any questions so far? But notice that the rules of professional conduct here do not contain the discipline. Discipline is a separate thing, Title 5 discipline. Let's see what that says. Rules of procedure, that's probably these. And you may not be satisfied with it as far as whether it really talks about does it talk about investigation? That's not clear here. The Office of Chief Trial Counsel and Office of Probation. Okay, so that would be, I would say they might be the investigators. And that would also give you clues for doing a web search. And here's where it brings you to business and professional code. So is this all making sense to you folks? So yes, we did find out who is bringing the proceedings and so on. And you may have to go to a business or professional, or you may have to do a web search to know any more about the actual investigation versus charges being brought. Okay, I'm going to move on to Wisconsin unless there's a problem or question. Are you ready for Wisconsin? Because I know Wisconsin was listed too. And I'm going to basically do the same thing. Wisconsin state and federal court rules. My memory is that it's under Wisconsin Supreme Court rules. And there's lots of things. Regulation of the state bar, regulation of members of the state bar. And okay, there's all kinds of things. Rules of professional conduct for attorneys. It looks like Chapter 20 is the one. Yes, that would be familiar. Procedures for the lawyer regulation system, Chapter 22, I believe. This one refers more specifically to intake investigations. So Wisconsin people would have an advantage, but I don't want the fact that some states are easier to research in Lexis than another should not be an advantage for you. If you look in Lexis and find stuff that doesn't directly answer all of the questions, use it anyway. That's what I'm saying. Can I move on to another state, Illinois? California, Wisconsin, Illinois. I do have to go to several states pretty fast. Can you guys still see my screen, my Lexis? Sometimes it gets ahead or behind my voice. Okay. And why do I use table of contents? Does anybody know why I don't just do sort of a generalized search? You can search generally if you know a citation or source name or whatever, but if you don't know, I'd like you to keep drilling down and looking in the categories, because if you learn the categories, you learn research, you learn where things are in your state, and it will make more sense to you. So I'm going to Illinois state and local, local, state, federal court rules, and here's the Supreme Court rules. Judicial conduct sounds similar to what we want, but it isn't, because we're not looking specifically for judges, we're looking for attorneys. So rules of professional conduct within the courts rules would typically be the lawyer ones. Yes, and here's the familiar ones. And I think if we go down there, we're going to find that it does not have the procedures in there. Let's see. No, it doesn't. Okay, and I'm not seeing them up here either. Just kind of going through. Oh, admission and discipline. I just about missed it. Usually they're next door. This is an interesting combination, registration and discipline. And you find that most states, all states I've seen, do have some kind of an administrator who assists with discipline and reports. And you go here and you get back to the table of contents. And here's assistance of members of the bar. So they can investigate, the State Bar of Wisconsin can investigate. They probably have bar counsel within that. Now in my state, it's a little bit different. This is Illinois, yeah, right. Not too much different from Wisconsin, I don't think. Let's see. Illinois, let's go. Can we go Minnesota now? I know I'm going slowly, but if I go much faster, it gets off so that what I'm saying doesn't match up what you see. Minnesota state and federal court rules. And Minnesota, for being a fairly small population state or medium, over 5 million, but not one of the larger states, has lots of rules. The only one I've ever heard of that has both civil procedure, criminal procedure, and general rules. Nobody else has ever heard of that. But we used to have, it used to be even worse. You had special rules for each district, in some cases each county, which was ridiculous. Well, there's still some special rules, but at least they've cut down. In my lifetime, they've tried to fix it a little bit, but it was a total mess. But here's rules on lawyers' professional responsibility, which sounds like the code, but isn't. This one's the actual code, what to do and not to do, Minnesota Rules of Professional Conduct. And again, similar to the ABA code, but this one's enforceable. Okay? And then rules on lawyers' professional responsibility allows you to have a district ethics committee. And so there is some, lawyer involvement of ordinary lawyers. Usually work as volunteers. They're not paid. But then you have the lawyer's professional responsibility board and the director, and they investigate and do things. Again, use this. So you have two different things: rules on lawyers' professional responsibility and Minnesota Rules of Professional Conduct. So get to know the fact that the every state I've looked at so far, the rules on procedure are a different set of rules than what to do and what to not to do in practice. Okay, one more check off. Checked off Minnesota, Wisconsin, California, Illinois. Let's try Oregon. Oh, Illinois, yeah. Try Oregon. Aren't you glad I didn't say Oregon? No, we're not supposed to say that. Oregon, right? And thank you for not saying Minnesota, because hardly any of us talk that way anymore. Other than in the old movie Fargo, there was, and my sister knows somebody who still talks that way, but most of us don't. Or at least we don't think we do. Okay. Here are rules from Oregon. Let me see here. Uniform trial court rules, civil procedure, tax court appellate procedure, shorthand reporters, United States District Court, Oregon State Bar rules. That's starting seeming suspicious to me. What do you think? Who voted for Oregon State Bar rules? I found out I went to a bar association meeting in Minnesota recently by remotely, one of our remote meetings, and I found out that we now have mandatory arbitration of fee disputes now. But here's client security fund rules, also delegates, contingent fee agreement. There's all kinds of things. Again, Oregon State Bar rules of procedure are different than rules of professional conduct. So the rules of professional conduct would be the good old things that you can do and you can't do. Similar, again, structured somewhat or very similar to the American Bar Association model rules, but these are enforceable by, and what are the procedures? I'm guessing right here, Oregon State Bar Rules of Procedure. So what has to happen? Somebody from the State Professional Responsibility Board has to investigate, right? Again, if you are really stuck on your state and you're really curious, you know, I would still cite the all of these things which we're looking at, which are all primary sources first, and then after that, if you want help finding something on the in the courts or bar association, I will help you with that. And I guess those could also be considered primary sources if they're the only things available. Okay. Oregon. We've still got Pennsylvania and Missouri. Thanks for your patience. I realize you're looking at other states and you're seeing that it's similar, but not precisely the same. But I think in some ways it helps you understand it better because you can see things that have to be done almost exactly the same to make sense. And then things that are slightly different or slightly different wording, that the involvement of the State Bar Association is different. If the State Bar Association doesn't include all lawyers, like in Minnesota, in some areas less than 1/3 of the lawyers are members because they don't want to pay an extra dues, they don't like going to meetings, whatever. But in other states, everybody is a member whether they want to be or not. And of course, when there's mandatory membership, then it's more of a formal setting, and the State Bar Association is more involved with actual discipline. Say in Minnesota, it's voluntary. So Same thing, I'm going to go to statutes and legislation, then Pennsylvania local, state, and federal court rules. And this is not it. See, and I just keep scrolling down until I find it. Okay, rules of conduct for magisterial district judges, that wouldn't count. I mean, that counts, but it doesn't count for what we're doing right now. We're not really concerned with judicial right now. It's nice, though, to know that these things are there, because if the judge calls up lawyers and harangues and harasses them about cases and then tries to settle cases on the phone with just one lawyer and not with the other lawyer on the other side, it's nice to know about this. So when you file an appeal, not necessarily you by yourself, but when you and the lawyer file an appeal or protest to the chief judge and so on, you know where you're at. Right? Here's rules of professional conduct, similar categories again. It's kind of neat that there's some uniformity, but also, again, these rules of enforcement have different titles in just about every state. So you have to hunt and peck for them. When you find something one way, though, try to find it another. Let's see, a lot of times your general searches don't work. Try a general search. Bar, discipline. If you don't use exactly the right words, it may not work. See, and you end up, although you get some backwards things, and you can find the wrong thing, and then you end up going from here, the wrong case or a case, and then you find some kind of a clue within the case, and then you can try to find that. So PAR, Disciplinary Enforcement 216. So when you find something one way, try to find it another. That's one of the clues for doing Lexis. Let's see, PAA. Well, it does quite okay. No, I have supervised practice. Well, there's a anyway. Again, the big part of can you, I'll hold it up to me. Can you hear me better now? Yeah, it's not clear. Were you able to see what I was doing? I think I explained well enough. Okay, well, I'm holding it up to my face, so I'm not going to be able to do as much typing or whatever, but why don't you, can somebody unmute? Cindy, can you talk from where you are, or do you have noise there? Can you unmute and, hit your microphone and talk? Why don't you run through these questions, and I'll just kind of point to the answer. Okay. This one is the answer, which is enforceable by the government. C. Okay. Which is not a rule that paralegals should avoid. I tried to make this obvious, but it's just basically review. You're just trying to review basic stuff right now. The quiz is worth 10 points, and the written assignment is worth 25. But don't forfeit the 10, because the 10 signifies that you did a review. You want to get some of those 10 points too, not just do only the 25-pointer, okay, which is the written. This is the written, and this one is the quiz, okay? Points. Okay. The paralegal, this one is a little difficult. A paralegal duty to report does not extend to what? It's really only one answer. These three are similar, so that kind of clues you in that the answer is D, negligence. And that's kind of shocking in a way, but negligence is sort of in the eye of the beholder. So you're not necessarily needing to report something that might be a lawsuit. It's more, these things are clearly unethical. Negligence is also somewhat unethical, but it's not as bright of a line, not as clear who's negligent and who isn't. Paralegals who act unethically cannot always look for double negatives in questions. You have to analyze those logically. It says it wasn't being recorded, but I thought it was. Okay. Yeah, they can't be disbarred. But whenever you see a double negative, analyze it logically. Okay? It's never for emphasis. If a non-lawyer said, I've never been to jail, what does the non-lawyer typically mean? Has that person been in jail? A non-lawyer. Well, if you don't analyze it logically, it's just for emphasis, right? Never, never just means never. But if it's said by a lawyer and you're supposed to analyze it logically, if they've never been in jail, that means they must have been in jail at some time. So you have to be kind of clever answering double negative questions, okay? So you have to go back to 9th grade English. And a lot of folks did not pay a lot of attention to that. I realize that. But there are double negatives in standard English. But unless it's something casual or whatever, if it's a strict language like for legal work or legal questions, you have to really be strictly logical. And sometimes lawyers even use triple negatives, and they mean it. A triple negative ends up negative again. 2 negatives makes a kind of a positive, and it's almost like math. It's like I say, it's kind of creepy for people, but do it. Which of the following is permitted to a paralegal? Information gathering, drafting complex. And they can be tricky even though it's not intended to. Drafting complex legal documents sounds wrong, but then you read for the attorney. So you're not handing it to the client without the attorney involvement. So this is okay. So yeah, A and B. These are, eliminate the ones that are clearly wrong, mentally cross them off, or have a note paper, you have enough time. And mentally cross off a couple of choices early on. And then analyze the others logically, but don't use too much imagination in a exam. Try to avoid imagining other possible things. Remember that if you had to come up with an exam for your own kids, you wouldn't want to argue with the kids endlessly about things they could imagine that would be an exception. If you had, like I say, if you had a clever 11, 12-year-old, 13, 14-year-old, they could certainly imagine any number of exceptions. And you wouldn't be able to come up with a good practice quiz for your kid, would you? But so you say, well, no, you're going to have to just give the basic answer, but analyze it logically and then move on. You're asked to thoroughly research a legal issue involving ethics. A good way to handle this is A, use your notes from class and assume no rules have changed. That looks wrong, so I'm going to cross that one off, okay? Use information from the instructor in course lessons. That's a good answer, but I'm guessing it's not the best answer if I'm sitting there like you, okay? Cindy, what do you think? I can't hear you, but yeah, it looks like you were unmuted. Somebody else? So this is a good answer, but it's not the best one because what did we emphasize? Use methods taught in the course and research. So you want up-to-date information. You don't want, I'd like to think that I have good answers for things, but really what I'm teaching you is methods, and you'll have to look up the final answers. Because even if I'm right today, I'm not right 5 years from now. There may be an exception or an additional rule that I don't even know about. How can I predict it? This may continue to be a conflict of interest exception. A conflict avoided by a leaky wall. Leaky wall sounds dumb. That doesn't sound like what we talked about with an ethical wall. No, that's okay. If somebody wants to talk, that's fine. If they don't want to, that's fine too. Conflicts that's been waived by one side of the lawsuit. This one, if you're in a hurry, you might think this is a pretty good answer. And sometimes it might be an answer. Sometimes it might be an answer, but it's not probably the best answer, so let's cross it off. This one seems like a good answer to me because I'm in the instructor, but it's not the best. B is the best. Okay? You only get points for the best answer, not an arguable answer. Conflicts checks are a waste of time. I'd say they're hardly ever a waste of time. Even if you had a brand new law firm that's never handled anything before, a brand new case, I'd say it's not a waste of time. But again, that would be using too much imagination. If it doesn't say it's a brand new law firm that's never had any cases, this seems off the wall from what we talked about. We talked about being thorough with conflict checks, so D seems like an answer. Actually, I put the wrong letters here, but you know where I'm getting at. Okay, well, that's what we needed to cover, and I was a little too thorough. We went overtime, but we had some audio issues. So did I answer your questions, or do you want to point me? The main thing is just use primary sources, because that's your real takeaway. You have a basic grasp of ethical rules, but the launch point is where you can look them up yourself and say, hey, boss, I looked up this ethical rule, and there's a related case that looks pretty alarming. It looks like we're not even able to get a waiver on this conflict. Or it looks like the other side that we thought never should have waived anything, they should not have gotten a waiver from their client or whatever. Maybe it's okay. Look at this case decision. So I want you to be able to do that in the rush world. And that's what I want you to be able to take away from this. And, of course, it will translate to other things other than ethics, too. But that's your takeaway, your big takeaway, okay? I'm going to stop it now.